Hello and welcome to the Ken Vercammen Law Office Legal Podcast. This edition, we're going to talk about domestic violence restraining orders, and in particular, a unreported case, LB versus JP. Here, the final restraining order was reversed, where there was no judge finding of a need to protect the plaintiff. So, the facts briefly are: the defendant appealed from the final restraining order in favor of plaintiff and award of counsel fees to plaintiff. After meeting at work, the parties began a 2-year dating relationship. After their relationship ended, plaintiff married another woman he had been dated, while defendant left the company the parties worked at. Plaintiff filed a domestic violence complaint against defendant. The parties ultimately reached a civil agreement in which defendant acknowledged and agreed that any violation of the agreement would constitute an act of harassment. Thereafter, though, defendant contacted plaintiff several times through email and Facebook. The plaintiff then filed a second domestic violence complaint against defendant, alleging predicate acts of harassment and cyber harassment. At the trial, the plaintiff's wife and defendant all testified, and the plaintiff testified. The trial court made only one credibility finding, rejecting defendant's testimony regarding why she contacted plaintiff. Remember, the defendant was a lady. The trial court made no other credibility findings as to the witnesses who testified. At the trial court, the defendant testified, and the court found defendant had a purpose to harass defendant given her violation of the parties' agreement, her use of coarse language in the emails, and the trial court's rejection of defendant's reasons for sending the emails. The trial court accordingly entered the final restraining order and awarded plaintiff counsel fees. On appeal, though, the appellate court reversed and dismissed plaintiff's domestic violence complaint. The appeal court found the defendant's emails, while crude, did not rise to the level of harassment because defendant made no threats towards plaintiff. The appeal court also found the trial court failed to consider whether a restraining order was necessary to protect the plaintiff. And that's the case of LB versus JP. In domestic violence cases, they use initials. For more information on domestic violence cases, read some of the articles on website njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Currently, the cases are still handled through Zoom, so there's not even a need to have to drive to courts, etc. Thank you.